30.
Yes.
If it pleases your lordship, I beg to appear for the petitioner, my lord.
Right.
My lord, before my learned friend start, I must, my lord, say
Get
one
started
thing.
already.
No, my lord. The entire issue has already, my lord, pending before the district magistrate. District magistrate has already, my lord, taken out the matter. Hearing was taken place. All the parties are represented. Now, my lord, this is award for order or judgment. This is the crux of the matter.
Page 132, my lord.
In my respectful submission, my lord, this is repetition only to create pressure. The person who has affirmed this repetition, he first moved for individual capacity, but my lord was generous enough. My lord directed relief to the realm. All the persons who are active, my lord was pleased to give them relief. Thereafter, the society, Gulaga, they moved. My lord passed the order that yes, whoever approaches, they will get electricity. Now this is the third time, same prayer, everything is same.
My
And
lord,
the
this is
district magistrate is season of the matter, my lord.
my lord, this is the fifth round of litigation, my lord. Initially, lordships were approached by the petitioner, I mean the secretary of the petitioner society, my lord, in his individual capacity. Lordship may kindly take up your lordship's order, my lord, at page 32, my lord. Relevant will be page.
What about the matter being pending before the district magistrate?
My lord, that will be answered by page 132.
Private respondents are raising
132.
objection. We are trying to effect
132.
connection. They are raising objection.
The first you are placing some other page, page 32.
Yes, that if your lordship may take the page 32, lordship.
Yes.
The relevant will be internal page 2, page 33, running page 33, the second paragraph, my lord. May I place it, my lord?
Please.
Learned counsel appearing for the private respondent number 9, who is incidentally is also the private respondent number 9 in this case, my lord, submits that initially respondent number 9 was the owner of the entire area. Subsequently, a portion of the area was sold out piecemeal to several vendors, who have subsequently formed an association by the name of such and such, who is the petitioner before your lordship in this case, my lord, which is a registered association. For the convenience of all the vendors, respondent number 9 has taken up the liability on itself to provide electric connection to all. Well, that was their submission before your lordship. Now, in view of that, your lordships observed at page 34, the next page, my lord, the last paragraph, my lord, keeping in view such end, learned counsel for the petitioner is granted liberty to file a composite but brief supplementary affidavit on the next occasion, indicating the support of the society, Samiti, as well as its members in the WBSEDCL, giving such individual connection to each of the vendors. So, as it was pointed out by my learned friend, my lord, that although the petitioner approached your lordship in his individual capacity, but lordship was kind enough, my lord, to allow all the applicant, my lord, to get implemented through the supplementary affidavit, which was complied upon, my lord. And based on that, your lordship was pleased to pass final judgment and order, my lord, which starts at page 36. Relevant portions will be, my lord. Operative part starts at internal page 5, running page 40, my lord. The second last paragraph, my lord, or the third paragraph from the top, my lord. Hence, WPS such and such is disposed of by directing the distribution licensee to immediately make the necessary installation and raise the structure necessary for giving electricity connection individually to the petitioner and or other applicants. So, my lord, made it very categorical that the order will be applicable not only to the petitioner who approach your lordship in his individual capacity, but also in terms of the supplementary affidavit to all the applicants. This order, my lord, was never challenged by respondent number 9. However, my lord, an appeal was carried from this order, my lord, by a third party, my lord, who said, my lord, that his right has been prejudiced. That your lordship will find, my lord, that appeal, my lord, was finally disposed of by the Honorable Division Bench, my lord, by a judgment and order dated 30th June 2022. Lordship would find that, my lord, at page 106. Relevant portion will be, my lord, internal page 3, page 108, my lord.
108, yes.
My lord, may I place it, my lord? The last paragraph. In the said background, learned single judge has not committed any error in issuing a direction to the distribution licensee to take necessary steps for installation and raising the structure necessary for giving electricity connection individually to the respondent number 1 and other applicants. So, my lord, the Honorable Division Bench also recognized the rights of the other applicants, my lord. Now, my lord, the important portion will be, my lord, if 3 lines below that, my lord, if there is any objection by the appellant, so, my lord, your lordship's order was carried in appeal by this appellant, and this Honorable Division Bench
By
was
this appellant means?
a third party,
By
my
the
lord.
third party.
Third party, my lord. And the Honorable Division Bench, my lord, was pleased, my lord, to restrict the objection to the appellant. So, my lord, if I place it, my lord, if there is any objection by the appellant in that process, then the steps which are required under rules such and such are to be taken, my lord. So, your lordship's order was modified to this extent only for the appellant and none others, my lord. That being the case, my lord,
But the objection, right of objection of the others cannot be stulted by the court.
but since lordship, respondent number 9 was before your lordship, in the 20, the first,
Anybody and everybody can object to that.
the reason why your lordship did not entertain the objection was 3 reasons, my lord. It was not in air that your lordship passed that order, my lord. Lordship took three things into consideration. Number one, they were the initial owners who sold the land with income with the
Respondent number 9's rights were in this context were discussed.
was discussed, my lord. Respondent number 9 said, my lord, they were the owners. They sold
Yes.
the land. After selling the land, how can they object? Number one. Number two, they were selling electricity illegally to these vendors at 3 times the rate. So all these things were considered, my lord, and thereafter their rights were their objections were discarded by your lordship, my lord. So that being the case, my lord,
So what happened after this?
after that, my lord,
Somebody else raised an objection.
no, they themselves. Now I will tell you-
9.
9 only. I'll tell you, lordship, my lord. Thereafter, my lord, there was an interim order to provide interim connection, my lord, in the by the division bench, my lord, in that appeal. We wanted that similar, my lord,
Order
facility
to yes.
extended, my lord.
Hmm.
We approached your lordship. In this case, my lord, the association approached your lordship, my lord. That and your lordship was pleased to pass an order which starts at, my lord, running page 115, my lord.
Yes, 150.
My lord, the relevant portion will be, my lord, page 122, internal page 8, my lord.
Right.
It is expected, my lord, may I place it, my lord, second paragraph. It is expected that the necessary infrastructure required for giving independent electric connection to the people in the locality in question shall be developed by the distribution licensee as expeditiously as possible, of course, in accordance with law, my lord. So lordship passed this order, and lordship was also kind enough, my lord, to direct them to explore the possibility of giving temporary connection, which they, my lord, refused by a letter dated, my lord, 29 September
They
20.
did not have the infrastructure also.
Of course, my lord. That starts at page 124, my lord. Relevant will be, my lord, page 126, the last portion, my lord, last paragraph.
Hmm.
May I place it, my lord?
Hmm.
As per the observation made in Mat so and so with can so and so, as well as WPA 20440, this was the application made by the society, my lord,
Hmm.
in which your lordships directed them to give all just to clarify, my lord, give connection to everybody in that society, members of the society who have applied, my lord. As per so and so, an application as per rule 3 of the works of license rule 2006 has been made before DM. So they say, my lord, as per your lordship's direction, they have referred it to the DM. So this was done, my lord, that was referred to the DM as per them. On kindly mark the date, my lord, on 29 September 2022, they say, my lord, that as per your lordship's direction and order, they have referred it to the DM, my lord. Accordingly, my lord, lordship would find DM passed an order. That order lordship would find at page 132. This was my reply, my lord, to their question that what about the matter pending before the district magistrate, my lord. Page 132, my lord, DM passed an order dated 22nd of November 2022. So the reference was on September, and on November the DM passed an order.
Hmm.
In this order, my lord, DM determined the compensation amount and allowed the work to be carried out.
Compensation given to whom? 9.
To know, my lord, the third party
Very
objector,
well.
my
Yes,
lord.
yes, very well.
And the work was supposed to resume. It resumed, my lord. But what this third party objector did, my lord, instead of preferring an appeal, if he had if he was aggrieved with that order, my lord, in terms of rule 3, my lord, he approached your lordship by filing a writ petition, my lord. And the the distribution licensee, my lord, on the pretext of the pendency of the writ petition, denied to, my lord, advance with the work. Now your lordship will see, my lord.
The third party sought a modification order from me.
Yes, my lord, challenging the DM's
A fresh writ petition.
fresh writ petition, my lord.
What happened there?
My lord, kindly just give me a moment, my lord.
Yes.
Lordship would find at page 167, my lord, the order passed in the writ petition, my lord.
Yes.
Now, my lord, they said that they have not attached necessary parties and all that. My lord, we appeared before your lordship, my lord, and we requested, my lord, that, my lord, due to the pendency of this writ petition, my lord, electricity connection has not been affected. So your lordship clarified, my lord, on the last page, internal page 2, running page 168, the last portion, my lord. It is made clear that no interim order has been passed at this stage, since the matter has not been heard even on prima facie merits. However, the mere pendency of the writ petition shall not come in the way of the distribution licensee giving electricity connection to any person. Now, my lord, when this happened, my lord, what they did, this your lordship passed on 9th of January, my lord. 9th of January 2023, my lord. Immediately on, my lord, 11th of January, lordship kindly sees the page 169, my lord, annexure P20. They considered the objections of the respondent number 9, my lord, and referred the matter again to DM, my lord.
By now, I have forgotten the chronology.
My lord, I will assist your lordship in.
Please do that.
My lord.
Because what happened immediately prior to this, I mean, the 2 steps prior to this, the objection was, third party's objection was referred to the magistrate.
Magistrate, my lord.
An order was passed on that,
Order
that
was
was carried out, an appeal, a challenge was carried out.
Before this honorable court, my lord, before your lordship, my
Writ
lord.
petition is still pending. That
No, it is dismissed for default, my lord.
they will dismiss for default. In the meantime, this order was passed.
Yes, my lord.
They made another reference.
Another reference to TM, my lord. Now, this time they say, my lord, respondent number 9, whose initial objection was discarded by your lordship. They never preferred an appeal from your lordship's order, my lord. They accepted your lordship's appeal. Now they're again objecting, my lord. And they are the most,
What are challenged here?
my lord, we are seeking connection. Number 1, we are seeking compensation because of this delayed, and we have sought, my lord, if there is a, because one more thing, my lord, may I point out before your lordship, my lord, in the letter denying us temporary connection, they say, my lord, the distribution licensee says, my lord, that there is an internal line through which the respondent number 9 is giving connection to individual. We don't have a control over that internal line, and therefore we cannot do anything about it. So we wrote a legal notice to them. My lord, paragraph F.
Yes.
My lord, paragraph 3F in a bit, my lord, kindly, since I have said the contents of it in brief, my lord, as mentioned in paragraph 3F of your letter, the truck terminal limited, which is respondent number 9, my lord, is a bulk consumer of the WBSCDCL, over which the undersigned, my lord, he is the divisional engineer and station manager says, my lord, on which the undersigned doesn't have any jurisdiction and is above the pay grade of him, my lord, to lodge an FIR, my lord, for illegal. He says that he doesn't have any jurisdiction, is pay grade of him, my lord. Unheard of, my lord.
What does he mean by this? Respondent number 9
That
pays
can-
less to him than the other officers.
That will, my lord, senior friend will explain before your lordship, my lord. But what I understood is this.
Probably that way.
No, my lord, who have taken.
What is about this pay grade?
The English may not be, my lord.
English.
But, my lord, I
Pay
get your
grade,
lordship.
somebody is saying pay grade, he doesn't know English.
It's wrong. What has happened, Milord? Say bulk connection consumers. Suppose like Milord, the shopping mall. One connection will be
Give
there.
me a report,
and they will-
Mr. Kohler, give me a report as to what have you done with regard to this
No, I clear.
illegal supply of electricity.
No, not illegal supply. I clear to your lordships. My learned friend says, Milord, the again reference to the district magistrate is not,
Yes.
is not the real fact. What has happened? Pursuant to lordship's direction in earlier writ petition, we have complied. We have given connection, all the consumers, whoever there. Now, subsequently, by taking.
You have given the connection.
Yes, by taking advantage of your lordship that others, now after completion of that connections, others consumers are coming into the play. And we are trying to effect connections. Now at this point, respondent number 9 is raising objection. We are to install 11 ports. They say this passage sought to be install the pole, it is belongs to me. We have raised objection. We don't allow him to install pole. Now, again, the matter has been referred to the district magistrate, and district magistrate hear out the matter. This is the second time,
My
not
lord-
the first. My learned friend is trying to all assemble together. That was complied with.
So every time somebody will apply for electricity, they
But what
my
can
lord-
be done? He says it is my land. I will not allow.
Anyway, let me complete, Mr. Chattopadhyay. I'll come to you after that.
Just to clarify, my lord, what my lord, senior friend has said, my lord, I think, my lord, he has been quite misguided by his client, my lord. If your lordship takes up, my lord, the list of applicants I have provided in my writ petition, my lord, page number 43, my lord. If my learned senior friend can satisfy your lordship that all 68 connections, my lord, have been provided, I am out of the court with cost, my lord.
No, not
I don't mind.
68. I am not saying 68. I am
My lord,
saying
this is
that
this is the list of applicants that was annexed along with the supplementary affidavit, along with the writ petition which was filed by the society. If my learned senior friend is with the instruction that they have provided us connection.
I
and
am not
express
saying
connection
my
has been-
understanding Swaras Milot is not, I am saying Milot, initially we are installed 10 poles. We are able to install 10 poles and we have given connection up to that extent. Now Milot, another 11 poles are to be required to be installed for the purpose of effecting connection to these consumers. Now when we are Milot taking steps, the respondent number 9 raising objection that we are not allowed to install the pole. That is why, Milord, the again matter, that portion has been referred to the district magistrate, and district magistrate, as per rule, your lordship knows, and district magistrate has already heard out the matters with all the, including my learned friends clients also present. And Milord, now, my instruction is, now we are yet to
My lord, there is
get
a
the order
syndicate.
from the
There-
district magistrate.
There is a
Even
syndicate, my
inspections
lord.
also.
If your lordship.
Why are you not giving the connection? Because it is pending before the district magistrate.
No. They are not allowing us to install pole. We have to
Yes,
install.
now that is pending before the district magistrate. They have taken out what is pending before the district magistrate.
So far, 11 poles is concerned, rest of the poles.
That is what I am asking you, Mr.
Yes.
Kolle, that has been referred to district magistrate.
Yes, and that district magistrate has already, Milord, taken, hearing all the parties, all parties are before there. Now we are yet to, Milord, the order for the, from the district magistrate.
Yes, every time Mr. Chattopadhyay, I'll come back to you. Let me hear the respondent. of
Perhaps the petitioner has failed to give the clear picture.
Nobody is giving me the clear picture. I don't expect a clear picture
I will
also.
try to provide the clear
Give me a
picture.
blurred picture, but why are you resisting again and
No,
again
my
and
lord,
again and
this
again?
is not the fact at all. First of all, when the
I'll record that you're not resisting and
No, my
direct him
lord.
to give connection to
my
honor.
lord, kindly allow me to complete, my lord. When Partho Roy, the person affirmed this petition, came before this honorable court, claiming that respondent number 9 is raising the objection. What happened to that matter? When the ACDC, WB ACDCL personnel went there, they found that the land is not mine. Somebody, third party's land is affected.
You
So
are not giving any objection.
today the picture is totally different. Today
Look
the
at this
WB
picture.
ACDCL does not know from where the land has to be acquired.
So why are you objecting?
Nobody is objecting right now. Now the matter is
I'll
pending.
record that you are not objecting.
My-
I'll direct them to demolish your objection.
I cannot object until and unless it
Raise
is
your
notified.
voice.
Well, I'm sorry.
Don't raise your
I
voice.
cannot object until
Convince
and
me
unless
otherwise.
I cannot
Please.
object until
Voice,
and unless-
raising voice does
No,
not
no,
convince
no.
me at all.
I cannot object until and until it is known that which land will be acquired. Nobody knows which land will be acquired. On the last occasion when the matter was taken up,
We don't know what is being acquired. What are you objecting to?
that the authority is yet to prepare a sketch map, a proposed way that from this way the poles will be installed. That was the hearing held before the learned district magistrate.
You have
We-
not objected.
I will object in the event it is.
You
be
will
on
object
the
means
mind.
you have not raised any objection. What is pending before the district magistrate? If you
Now
have not
the
objected,
situation is absolutely different, my lord. Now the authority does not know where.
I want a straight answer from you, sir.
If
Have you objected, filed any objection, written objection or verbal objection
I
when
have
this
stated that
WBSCD? No. Well, let me complete my question first. Have you given any objection which is pending before district magistrate at present?
yes, because today.
What about this? What about re? I'll give objection if and then and but.
My lord,
You have
the-
given an objection on what ground? Your right was closed by the previous order.
No, my lord, but that has been referred to the district magistrate by the appellate court.
And set aside the entire proceeding before the district magistrate. They'll give connection within a week.
That my lord
Why
can,
not?
that my lord can, but
Give me
today,
one reason why you are objecting after that previous order of the court. One reason.
my lord, these lands are used for our personal purpose. If they erect pole and if they give high tension line, we will not able to use our land in a proper manner. And today, my lord, the picture is totally different. Today, nobody knows whose land will be acquired.
Nobody
Therefore-
knows you don't have a right to object then.
But,
You also don't know. Nobody means you also are included
but
with it.
since we are the
You
major,
have no locus standi to
my lord,
object.
since we are the major landholders, we are apprehending that our land will be acquired.
On apprehension, objections cannot be filed, sir.
That is our case, my lord. That is.
I'll set aside that objection then. If you are apprehending something and objecting on basis of conjecture that this may happen, when it happens, we'll see. Yes, what answer do you have? It's pending before the magistrate because this is a fresh cause of action. 11 new pillars are being sought to post. It's actually running from pillar to post. So those are being installed now.
My lord, that your lordship.
So let that be decided by the magistrate.
That
Why
answer
not?
has already been decided. That's why I placed the later.
This same 11 posts.
Yes, my lord, 29 September later, like kindly see, my lord, 29 September later, my lord, which I placed before your lordship. my lord.
Page, give me the page.
Just a minute, my lord. So 124 is the starting, my lord.
Mhm.
13, my lord. Relevant will be, my lord,
Oh, that's
126.
very well, yes.
So, my lord, your lordship already they already took the cognizance of your lordship's
Who
order.
is Ajay Kumar Chaudhary? Raised
He is
by-
the third party appellant, my lord, who preferred an appeal. Whose
The
appeal was
objection by
allowed.
Ajay Kumar Chaudhary was decided
Was
earlier.
allowed. So, my lord,
That
you-
was decided
that was
by the
decided.
district magistrate, not their objection. Now
All
they are
objections.
objecting.
Like, kindly see, my lord, WPA 20440 relates to connection of 68 distinct applicants, my lord. Today's, before your lordship also are these 68 applicants being represented by the society, my lord. Same people, my lord, 68 persons. So that has already been referred in 29 September 2022. Kindly sees, my lord, as per 20440, if they had objection in terms of 20440. If not the earlier, because in earlier also they're the same applicants, my lord, 68 applicants. They were before your lordship. They were before your lordship in 20440. They were before the honorable appellate court, my lord, in which, my lord, your lordship's order was not carried up in appeal by the respondent number 9, my lord. As your lordship was correctly, has rightly observed, my lord, what is the locus standi of them to object, my lord, for twofold reason, my lord. Number one, they have not challenged your lordship's order, my lord. Number one. Number two, my lord, they say that they were the owners. So once they were the owners and they sold the land, the question that would fall for your lordship's consideration, whether they can have a valid objection, my lord. My lord, if I sell my land to your lordship and your lordship apply for an electricity connection, will I be a bona fide objector in that case, my lord? Coupled with the fact that, my lord, I am coercing your lordship to take electricity from me illegally at 3 times the cost.
This was page 126 is the decision taken on the previous occasion.
It was, my lord, lordship directed to provide them temporary connection. And in the event they cannot provide, they have to give a reason, my lord. In the
This is that reason.
This is the reason, my lord. In which they said, my lord, the objections with
Mhm.
respect to
My lord, kindly come to page 134.
134 is the last order of the
polls,
district magistrate.
8 polls. Your lordship kindly see. My lord has been saying is the rest of the 11, that is not. It appears that the
So
market
that
value
is,
of the
my lord,
quantum-
that is the
No, every time a new pole is being
my lord,
installed,
8 plus 11.
how many more poles are required to be installed?
Now, my lord, 11 polls.
11 are, this dispute
eight-
is regarding those 11.
No.
8 have been installed
Yes,
already.
8 has been complied.
Over.
Yeah,
What-
yes, complied.
how
Now
many
we have
else
to
remain?
install another 11 polls to complete all proceedings.
That is the
into-
scope of this dispute.
That is the scope of it.
So how can that be re-raised?
No,
It has been already
no,
11 polls, the
That
12th
was-
poll.
that was not earlier referred. The only 8 polls was
When
referred.
was it referred to the magistrate?
That was, my lord, resolved. 8 polls are
When
all.
was the 11 poll dispute referred to the magistrate? The last one.
Well, that was in, my lord,
More or less,
more or less February, and that was completed. All proceedings was completed. Hearing was taken place.
I'll
Everything was
direct the
completed.
magistrate to give his passing
Yes,
orders
yes,
within a
yes,
week,
yes, yes.
within a fortnight.
That
I'll
up
do
to your lordship.
my
my
lord,
lord.
that is one
It is
part
not
of
a case, my lord, that we are not
Oh, The
intent to.
difficulty is
effect
these are
connection.
11 more. 8 were decided. The rights have been decided. In the light of that, the magistrate will decide.
Yes, yes,
That
yes.
is all
Possible.
right, my lord. I'm not standing in that way, but my lord, kindly consider one aspect, my lord. Your lordship considered their objection. They raised objection before your lordship, but your lordship considered that since they are the owners, my lord, they sold their land to these vendors, my lord. They have an admission to that effect.
This objection now presently pending at present pending before the magistrate that has been raised by 9 alone.
Only line, my lord.
No, no, we have also referred. We have also referred.
Kindly
No,
see,
no,
my
you have
lord.
referred on 9's objection only.
Yes, my lord. Kindly page 174. my
I
lord.
was present in the hearing, Ajay Kumar.
So he says the present picture is different. How is it different?
My lord, kindly come to
Absolutely
page,
different, my lord.
my lord, page 1.
How different?
Let them say what.
You tell me how different.
Well, the difference is today the 11 poles where they will install the pole. That sketch map is not prepared. On the last occasion when the matter was taken up by honorable by the learned district magistrate, it was categorically submitted that they are yet to. They are yet to prepare the sketch map. In the event the sketch map is prepared, new persons may come. That is my only submission.
At order record. Ashun ekhane এসে Learned counsel for the petitioner contends that despite several previous rounds of litigation, even after the issue of the entitlement of the petitioners to have electricity connection at the location in question having been settled, the WBSEDCL is yet to give such connection to all the applicants, all the 68 applicants, who are represented by their association, the present writ petitioner. For sub next para, learned counsel appearing for the respondent number 9, the present objector, submits that the picture has altered in the meantime. It is submitted that the previous dispute arose regarding installation of certain other poles, whereas 11 new poles are being sought to be installed on the property of the respondent number 9, comma, for which the respondent number 9 was constrained to raise objection. Full stop. Next para. Such stand is reiterated by the WBACTCL. Full stop. Learned Counsel for the licensee submits that the current dispute has already been referred to the district magistrate and has been heard before the said authority. Full stop. The said matter is on the verge of conclusion, comma, awaiting the order being passed by the magistrate. Full stop. Next para. Upon hearing learned counsel for the parties, comma, it is clear that the matter is undoubtedly checkered insofar as its history is concerned. Full stop. Next para. At the initial stage, comma, when 8 previous posts were installed by the WBACTCL for giving connection to the members of the petitioner, comma, who had applied for electricity connection, comma, the present respondent number 9, within bracket, also respondent number 9 therein, bracket closed, took an objection. Full stop. This court, comma, in the order dated March 4, 2022, passed in WPA 2229 of 2022, comma, had decided the said issue. Full stop. Next para. Scrutiny of the said order indicates that it had been contended by respondent number 9 that they are the that it is the owner of the property in question and has been supplying electricity to the occupiers and vendors thereat. Full stop. Next para. The electricity distribution licensee had taken a stand that the respondent number 9 is a bulk consumer and it is not within the domain of the WBACTCL to supervise as to which persons are given connection by the said bulk consumer. Full stop. At internal page 4 of the said order, comma, it was observed by this court that due to resistance created by the respondent number 9, comma, the electricity connection could not be given individually to the petitioner and the other vendors, within bracket, which covers the present 68 applicants as well, bracket closed. Full stop. It was also recorded that the respondent number 9 had taken a specific plea as regards the route over which the connection was to be given, comma, being owned by the said respondent. Full stop. It was observed by this court that if a person is in settled possession of a property, he or she is entitled under section 43 of the Electricity Act 2003 to get electricity connection at his stroke her occupied premises, comma, subject to compliance of all due formalities.
May I take back
Full
your
stop.
lords?
But
May I came back to your lordship, my lord?
may you?
May I came back to my lord? One matter is
Oh, yes, yes, absolutely.
Great
Keep
question.
somebody. You don't have any junior. You're saving all the fees.
no, my lord, junior is there.
Yes, yes, immediately. But
Junior
then
is-
I'll pass certain observations against your client if you leave.
Lord, as you
Take that risk. Yes, yes. Moreover, the petitioner and other vendors' occupation of the area had not been disputed by either the distribution licensee or the respondent number 9, comma, it was observed, comma, although respondent number 9 specifically disputed the legality of such possession. Full stop. In such circumstances, comma, it was held that merely due to an objection raised by the respondent number 9 as to the legality of the petitioner's possession, comma, the right conferred on the petitioner and other vendors who are evidently in settled occupation, comma, under section 43 of the 2003 Act, comma, could not be curtailed, cannot be curtailed. Full stop. Accordingly, the writ petition was disposed of by directing the WBACTCL to immediately make necessary installation and raise structures necessary for giving electricity connection individually to the petitioner therein and or other applicants, comma, if any, comma, subject to compliance of all due formalities in law by the petitioner and the other applicants. Full stop. Next para, certain other consequential directions were also passed in the said order. Full stop. After the said adjudication, comma, a dispute was raised by a third party, which was ultimately decided by the concerned district magistrate. Full stop. The district magistrate, vide order dated November 22, 2022, comma, had ultimately observed that the licensee, that is the WBACDCL, shall pay an amount of rupees 17,934 to the private respondent for erecting 8 electricity poles and shall draw the electric cable through these poles to the petitioner. Full stop. Next para. Thereafter, the same was challenged, but ultimately no deviation was could be obtained by the objector therein to the direction of supply of electricity to the petitioner. Full stop. Next para. It is seen that at present, comma, the same respondent number 9 has raised objection when the WBACDCL is seeking to install 11 further posts on the land in question, comma, which according to the respondent number 9, comma, nobody is sure as to the ownership of. Full stop. Next para. Even supposing that the respondent number 9 is the owner of part or whole of the property over which the poles are being installed, comma, the works of licensee rules 2006 clearly specify that in case of dispute, comma, the same is required to be decided by the district magistrate. Full stop. Insofar as the present dispute is concerned, comma, the same pertains to the same subject matter which fell for consideration previously before the writ court and thereafter before the district magistrate. Full stop. The issue raised before the magistrate as well as the writ court was whether the WBACDCL was entitled to give electricity connection to the petitioners. Full stop. The corollary to such main issue was as to the amount of compensation, comma, if payable, comma, which was to be payable to the persons over whose land the installations were being made. Full stop. In particular, comma, the respondent number 9, comma, which was a party to the initial writ petition, comma, and is bound by the order passed therein, comma, cannot resile from such position and seek to reopen the final conclusion reached in the said writ petition by an order of court, comma, inasmuch as the right of the WBACDCL to give electricity connection to the petitioners is concerned, and or as to the right of the petitioners to get such electricity connection. Full stop. In particular, comma, the 68 present applicants had already applied at the relevant juncture as well, and their contention regarding their right to get electricity connection has been fully decided, conclusively decided on all earlier occasions. Full stop. After the writ court having turned down the objection of the respondent number 9 in the capacity of the owner of the land, comma, it does not lie in the mouth of the same respondent to raise similar objection when further electricity poles are being sought to be installed for the purpose of compliance with the order of the writ court and to give electricity connection to the other applicants who are also fruit vendors in the area. Full stop. Next para. Needless to say, comma, the applicants have to comply with other formalities, full stop, but comma, but insofar as the objection of the respondent number 9 is concerned, comma, the same has been rendered a non-issue after the previous adjudications and could not be reopened before the district magistrate again and again, comma, repeatedly. Full stop. Next para. Hence, comma, irrespective of the dispute raised by the respondent number 9 before the concerned district magistrate, comma, the same is a foregone conclusion in view of the order passed by the writ court on earlier occasions. Full stop. Hence, comma, the petitioner and its members, being the fruit vendors in the locality, comma, have a right to get an electricity connection individually for each of the applicants, irrespective of the objection raised by the respondent number 9. Full stop. However, comma, undoubtedly, the WBSETCL is also required to consider the question of compensation and quantum thereof, comma, if payable to the owners of the lands over which the 11 proposed electricity poles are being installed. Full stop. If a due application for compensation is made by the respondent number 9 or any other party, comma, the same shall be decided duly in accordance with law by the WBSETCL and compensation be disbursed to the entitled parties accordingly. Full stop. However, comma, in the event it is seen that the applicants are not satisfied with the compensation, comma, if any, comma, granted by the WBSETCL, comma, it will be open to such aggrieved persons to make necessary applications before the concerned district judge within the purview of the Works of Licensing Rules 2006 for an increment in the said compensation awarded. Full stop. Next para. However, comma, that there cannot be any further impediment in the electricity connection being given to the applicants over the 11 electricity poles which have been installed by the WBSETCL. Full stop. Hence, comma, WPA 12705 of 2023 is allowed, comma, thereby directing the WBSETCL to immediately take steps to give electricity connection to all the applicants who are members of the petitioner society, comma, whose applications are already pending, comma, irrespective of the objection raised by the respondent number 9 and or awaiting the outcome of the dispute raised before the district magistrate. Full stop. Such connection shall be given to the applicants in the pending applications as expeditiously as possible, comma, positively to all of them within 2 months from date. Full stop. Next para. However, comma, nothing in this order shall preclude the respondent number 9 and or any other aggrieved party stroke landowner to make appropriate applications for compensation. Full stop. If so filed, comma, the directions as given herein above shall take effect. Full stop. Next para. In the event the WBSETCL personnel face any objection from any quarter, comma, including the respondent number 9, in giving such connection to the petitioners, to the applicants, comma, it will be open to the respondent, to the WBSETCL personnel to approach the concerned police authorities for adequate police assistance. Full stop.
Respondent number 8.
Concerned police authority, comma, being respondent number 8, comma, the inspector in charge of the Sakrail police station, comma, Howrah Police Commissionerate, for adequate police assistance in that regard. Full stop. If so approached, comma, the inspector in charge, comma, Sakrail police station shall act on the written communication of the petitioner and or the WBSETCL and give such assistance to the WBSETCL personnel, comma, upon being satisfied on the basis of a server copy of this order without insisting upon prior production of a certified copy. Full stop. Such assistance shall be given with adequate forces, comma, if need be, by recruiting further forces from superior authorities, comma, at the cost of the petitioner society. Full stop. Notarized to cost urgent certified copies so that you can challenge us. But we'll argue, we'll try it. Thank you.
I'm so
Next
grateful, my lord.